Number seven is something I learned embarrassingly. So there's automatic revalidation, which is typically the scenario I've always seen it, which I thought was the only rule was that we have people who are here who come into the United States on a student visa, an F1, for example. The visa expires, but they're still going to school. If they visit Mexico and come back within 30 days with a valid I-20, even though the visa expired, they get automatic revalidation. They can just come back in as long as they're in contiguous territory, maybe Canada as well, and it's not for 30 days. So I always knew that, and there's some exceptions for it. For example, someone who's from Iran can't do that because that's an issue right there. Or there's a couple of countries. Let's see what countries they were. So if you have Iranian citizenship, state-sponsored terrorism countries, so Iran, Syria, Sudan, you can't use it, and that's what I typically ran into. But I was talking with a colleague who said, "Oh, we do change of status. Someone comes in on like a B2, changes status to E2, and then goes visits Mexico and can keep coming back." I'm like, "Oh, wait, they're not student visa holders. How could they keep coming back if they don't have that status?" So I went back and read the DOS site on there, and the CFR language is 8 CFR 2. I'm sorry, it's okay. Title 22, Chapter 1, Subchapter E, Part 41. So whatever that is, Section 41.112D, which goes into this automatic revalidation. But apparently, yeah, if you if you came in on a visa and then you have a new I-90, not I-90, is that what is it called? I-94 that's valid, you could do visa validation with some exceptions. It's like, again, the state-sponsored terrorism issue. If in possession of an F1 student or J1 visa exchange visitor traveling to Cuba, in possession of an M1 has traveled outside location other than U.S. and Mexico, you went to non-contiguous or adjacent islands. So it's more than 30 days that you've been out. So it applies to more than just student visa holders. And you probably already know, but it was news to me. But there's two more notes. One is you've applied for a new visa and was denied. It's like, okay, if you're already in the United States, I guess as if you left within 30 days, applied for a visa, it's denied, you can't come back. You shouldn't mess around with that. But another is if you apply for a new visa which has not been issued. But does that mean if you file for a DS-160 but haven't like had an interview, is that considered filing for a new visa? So you're here in the US, you fill out the DS-160, you go automatic revalidation, come back in, and you didn't even do a visa interview. Does that mean you can still come back in, or is that a problem? Or how does that work? So I guess the idea they're trying to prevent people from using automatic validation to try to get a visa, and the visa denied, be able to just come back in as a backup plan B. That may be it. But I'll just share that information with you. There's more to it you got to learn about, but automatic validation is an interesting, piece of law that exists. It can be really helpful. There was a nuanced case. Someone came to me. It was very interesting. So they were here on some sort of status, and they left the U.S. and then came back in with automatic revalidation. So they had a new admission. And then we have to file an I-539 for them to change status from a F2, a spouse of student visa holder, to a spouse of H-1B because their spouse got it. And the I-539, it says, since your last admission, have you violated your status? And the great thing was we could honestly say no, because they left and came back, had new admission. Whereas if they hadn't left, they would have had had a violation because they violated in some way. But that automatic revalidation saved them. Now, I guess if CBP asked them about the violation, they would have prevented coming in, but they didn't ask. And there's no thing in the here that talks about visa violation to come back in that I'm seeing. So it was an interesting thing to reset the clock to be able to do the I-539. And I think they had done the I-539 already, and they came to me in that issue of whether they had done misrepresentation because they had a violation, but they still filed an I-539 would have worked. And then they had the cutoff for that revalidation, so they had a new admission in the I-539. Let me pull up the form itself. It's very specific. It doesn't ask about all history. It just asks about recent history. And I think it's like 2 years ago. It's come back to me. I think they were going to adjust status now. And there was going to be employment-based adjustment status. So under 245K, previous violations are okay on previous statuses. So it would have been okay. So it was this nuanced situation that worked out really well. And it taught me the power of automatic validation to reset the clock and admission for the I-539 purposes. So I just pulled up the form right now, and here in the violation sections, a lot of questions about different things here. Let's see. Let me just control F it because there's a lot of questions. Admission. Okay, that doesn't come up. Violation. Let's see if it comes up. Violation. Have you or any other person, including this application, done anything that violated the terms of non-immigrant status you now hold? Is that how it was asked? I think it was different at the time. that you now hold on your non-immigrant status that you now hold. Does that mean? I guess that's a new non-immigrant status because you get a new I-94 once you enter on automatic validation, right? I think it was worded differently here because I remember saying since last admission they may have reworded it, but hey, just keep an eye out. This kind of stuff may pop up that can help you out. Okay.